Thanks very much, and it's great to be here. And I want to start by acknowledging the Maori culture and the Maori people as traditional custodians of the land on which we meet. I also want to thank the organisers of this event for inviting me to contribute today. As you heard, I am here to talk about listenability and the law, and certainly I think the subject of this conference is timely. For too long, the law has been an alienating construct premised on convention and language that was actually designed without the majority of its users in mind. Efforts have been made, of course, to improve the use of plain English in written information about the law and legal processes. Community legal centres and other sources of public assistance, including the Victoria Law Foundation, have been at pains to provide their clients with clear, comprehensible information about their legal rights and responsibilities. This is obviously crucial, as many Australians, and I'm sure New Zealanders as well, are still unaware of what they should do if they have a legal problem, or, as a study by the University of New South Wales revealed, whether the problem they face is in fact legal in nature at all. In fact, many are most likely to consult their GP about legal matters before anyone else. Providing clear, understandable information in accessible places, such as GPs' clinics, is therefore, I think, an important step in improving the public's comprehension of their legal rights. Whatever happens, however, if the problem escalates to the extent that people do come into contact with the civil or criminal justice system. Now, despite laudable attempts in recent years, most court application forms and orders remain impervious to the needs of court users, and we've heard about that right throughout this conference. To this end, in fact, research from Western Australia found that respondents to protection orders often don't understand the legal basis of their order or indeed the conditions it contained. As a result, inadvertent breaches, applications for variation and revocation clog up courtrooms that are already full to the brim. That's why the Centre for Innovative Justice has been supporting the Magistrates Court of Victoria to actually rewrite standard conditions of its family violence intervention orders. The task has been to identify wording and structure for the conditions which are not only easier to understand and follow, but which are also much clearer for police to enforce. So we've undergone extensive consultation with magistrates, with court personnel, with police, with lawyers and the family violence sector, and finally a draft set of conditions has been settled and will be shortly subject to group testing, focus group testing. This will of course involve people who have had a direct experience in this particular courtroom procedure, not just victims but also perpetrators of family violence as well. This process will actually allow us to test whether the language and structure of the condition is genuinely understandable to those who use them, and also makes perpetrators feel that it's in their interest to comply with what the order actually says. So certainly it's crucial that written information which parties receive before and after a courtroom experience is as clear as possible. It needs to support the exchange which has actually occurred in the court. But what about the clarity of that actual courtroom exchange? What about the way in which information is verbally communicated by courts, by police, by lawyers, by corrections officers and all other personnel with whom legal users interact? After all, for all its ritual and Latin phrases, the law is actually about people, with court a theatre purposefully staged so that the community can see that justice is being served. Ironically, it's perhaps for this reason that its language and conventions have remained so florid. A system, I guess, determined to put on a good show, to prove with all its horsehair flying and monologuing that the rule of law prevails. In the process, however, the system forgot about the people it was supposed to serve, creating an experience which is alienating and in many cases re-traumatising. And I can speak personally. When I was in Parliament in opposition, I applied for some documents under our Freedom of Information legislation. I had to go to VCAT, a court, to get those documents, and I was put in the witness box for over a day by the government's lawyers. It was a daunting and, can I say, traumatising experience. I didn't understand a lot of the language and a lot of the questions that are actually being put to me. That was the experience of a lawyer, a politician, a middle-class, white, tertiary educated male who wasn't even on trial. What's it like then for a person unfamiliar with the legal process? Someone for whom English, for instance, is a second language, someone who is actually on trial. What's it like for someone from a community which the system has disproportionately criminalised? Well, I can tell you, when I was much younger and I was doing Aboriginal legal aid work in North Queensland, I sat in the back of the court waiting for my case to come on, and I was watching a coronial inquest take place. The only witness to a single vehicle collision in which a person died was an old Aboriginal bloke who was sitting on the side of the road. He was called into the witness box to give evidence about what he saw. He looked around, he saw all these white faces, he saw the white coroner, the white police officer assisting the coroner, and he said, "I'll plead guilty." Sad story, but a true story. That's how alienating the justice system can be to some people. What's it like for someone who has an intellectual disability or an acquired brain injury? What's it like for someone who's applying for a protection order and feels terrified just to be in the same building, let alone the same courtroom, as their attacker? Certainly, research reveals the effects that stress can have on our capacity to retain verbal information. One study of parties to protection orders revealed that they'd forgotten around 70% of what was told to them once they left the courtroom, and 90% of what was conveyed to them by the end of the week. Complicated language, however, and the detached personal manner of many legal personnel can actually make matters worse. For example, in another study, even trained police officers couldn't remember the contents of a police caution when read to them in a situation simulating the stress of being temporarily detained. This suggests that clarity and comprehension is not just about what is said, but actually about how it's said as well. Absolutely, we know that the way in which people are treated in a legal encounter, in particular, how fair and indeed respectful they perceive the experience to be, can have a significant impact on their ultimate view of the result. In other words, people who have been dealt with respectfully and fairly in a courtroom are much more likely to perceive the result, even if they've lost a civil claim or indeed they've received a criminal sentence, as just. What's more, they're more likely to comply with the decision of the court. Ease of understanding has to be a factor in this experience. Certainly the range of solution-focused courts I had the privilege of establishing in Victoria when I was Attorney-General were premised on making the court processes more understandable, more meaningful for the court user, and indeed providing court users with wraparound support services. Of course, a lot of this relies on the skill of the individual magistrate, a dedicated professional who has experience with a range of court users and who is invested in helping each one of them to understand. What about other court users though? What about those who don't get the opportunity to experience an interaction with those solution-focused courts that I've spoken about? Certainly the vast majority of people with acute legal needs in the civil sphere to an extent, but definitely in the criminal justice sphere, come from backgrounds of severe disadvantage. In my home state of Victoria, the State Ombudsman conducted an investigation recently into the prison system, and she confirmed that only 8% of its populations had completed secondary education, in comparison with about 90% of the general population. Over half, meanwhile, hailed from just 6% of the state's postcodes. Over half had a significant mental health issue, and 44% of male prisoners and 33% of female prisoners had an acquired brain injury. It was with this latter aspect in mind that we devised our Enabling Justice project. We wanted to improve understanding of the way in which people with an ABI, an acquired brain injury, interact with the criminal justice system, and to put those people at the centre of this work. We went about this through a careful literature review and through qualitative interviews with people with ABI who have actually experienced the criminal justice system. Perhaps most crucially, some have also formed a justice user group, being central to the project's objective of enabling the voice of these users to shape our proposals and ensuring that this platform could build their capacity to advocate for their interests elsewhere. This project has found that at every point, every single point of interaction, the justice system does not understand acquired brain injury, while ABI undermines people's ability to understand the justice system. This is not just a matter of clarity and communication, of course. ABI is a complex and varied experience, and we shouldn't assume that in every case it means that people are less able to understand complex language or concepts. That said, it definitely compounds the challenges. In the context of people's interactions with police, it meant that police often didn't consider or didn't understand people's potential need for assistance. Once an individual gets to court, the experience is similarly alienating. Participants described feeling fearful and stressed to the point where some would drink, some would take drugs prior to turning up, or simply just not turn up at all. Many described not understanding what had occurred. As one participant explained to us, "I've been sent home, but I put my hands together to get locked up because I thought I was going to jail. I was waiting for him to come and get me, but he let me go." In terms of prison, following the directions of prison guards and remembering medical appointments were especially challenging. As one participant said, "If you don't hear the call and you aren't there in 2.5 minutes, you miss out. And that can put you in a psychotic episode, and the next minute you're in the slot. You're in the slot with a canvas dress on." Complying with the demanding routine of parole or community-based orders, meanwhile, was too much for many participants without appropriate support. "She couldn't understand my misunderstanding," one told us. "She nearly locked me up for not turning up to my appointments when I made it quite clear to them that it doesn't matter what you say, I'll forget." So, what is the way forward? There were many broader and compelling observations from our justice user group, which, can I say, paint a pretty grim picture of how the justice system fails them at every conceivable point, entrenching disadvantage, effectively disenfranchising disability. By painting this picture, however, we also identify opportunities for change. We're currently in the process of consulting on and refining recommendations for this reform. These have been informed by certain underlying principles, the first of which is procedural justice, the concept I discussed before. One justice user group participant put it pretty succinctly: "The way the judge was in the ARC list, which is Mental Health Court in Victoria, he respected me, so I gave him some respect back." Equally important is the principle that justice should be solution-focused, another concept I referred to earlier, and it was encouraging to hear the difference that these solution-focused courts made to the enabling justice participants who'd encountered them. One told us, "The magistrate said, 'Why don't you come up here and sit at the table?' And I didn't have my stomach rumbling. He shook me hand one time too. I want to go back there, but just to say hello." The next interconnected principles are those of universal vulnerability and universal design. These will be familiar to anyone in the disability sector, but remain fairly untested in the context of a conventional legal system. A system, can I say again, that was designed without the majority of its end users in mind. What universal vulnerability means is that because of this original design flaw, everyone who comes into contact with the criminal justice system can be vulnerable. As one participant remarked when reflecting on the stress he felt when attending court, you don't have to have a brain injury to feel all that. That's just stock standard anybody. As a result, a system that operates as if all of its users are vulnerable will assist everyone, including those with cognitive impairment, whether formally diagnosed or not, whether known to the individual or system more broadly, or whether it remains hidden. Accordingly, the interconnected concept of universal design means that we should be working to redesign a system that's actually usable by all people to the greatest extent possible. This means processes and language that are simple and understandable, an imperative that's relevant not only to people with an ABI, but to anyone whose comprehension might be impaired by low levels of education, by fear, by heightened stress, or simply by lack of specific legal training. As one participant explained, the judges throw around big words. I'm thinking, what the shit is she on about? This is where the concept of listenability comes in. As Clarity has pointed out so well, use of plain English is not just about dumbing down language. It's about using common terms and language which are conscious of the target audience and actually tailored to their needs. Concepts of listenability, however, take this understanding further. Many judicial officers already use these tools in their daily courtcraft, of course, but research conducted by our centre confirms that certain elements are essential if court users are to understand what's being said to them. The first is some instructions. In other words, by instructing the individual to pay attention before giving them important information, it allows them the opportunity to anticipate that information, to give it context, and indeed to prepare for it to be absorbed. The second one is actually to give people a list. Providing people with a list of the information which is about to follow gives them a method by which to organise this information in their mind. Most importantly, it reduces the cognitive burden that it imposes, potentially enabling them to retain the information beyond the end of that day. The third crucial element is to explain, repeating information by paraphrasing and doing so in words which are commonly used. Using all three of these tools, instructions, lists and explanations, used concurrently was found in relevant studies to be most effective. Now, it might sound pretty much like common sense and pretty simple, but then again, simplicity and common sense are not always in the job description when governments appoint judicial officers. So what might it sound like in practice? Following these three simple guidelines, this might involve the magistrate, judicial officer, giving an initial instruction. I'm about to make an intervention order against you. It's important that you listen. An intervention order is designed to protect people, and this one protects X. It contains conditions that stop you doing certain things. Then, a list of conditions. There are 6 conditions attached to this order. You can't go to X's house. You can't contact her by phone or by email or on Facebook. You can't try to contact her through other people. The only way you can contact X is through her lawyer. The intervention order will last for 6 months. It can only be changed by a court. You can't get X to agree to that change. If you break these conditions, it's a criminal offence. Then finally, the explanation. I've just made an intervention order against you, and we've talked about the conditions. It's really important that you follow these conditions so that people are kept safe and so that you don't get into trouble with the law. Some judges know this intuitively, others do not. Some are too concerned with sticking to the letter of the law, repeating the exact paraphrases in legislation, mentioned earlier by Eamon, which are specific and legally accurate, but which mean very little to the people who need to understand them the most. This means that judicial officers need more training in clear communication and in skills such as motivational interviewing, which help procedural fairness prevail. It's through work such as our Enabling Justice project with individuals with ABI, as well as our work to improve family violence intervention order standard conditions, that we can start to make a clearer case for why this needs to actually occur. So, I conclude on this note. I certainly believe that police, that courts and corrections and policymakers alike are indeed looking for opportunities to improve the system for all who use it, to improve it for those individuals whose vulnerability is unidentified, as well as those whose vulnerability is known. By recognising our responsibility to correct the flaws in the system's original design, however, we can start to make a positive intervention for all who encounter it, and thereby safer, clearer and more effective for the community as a whole. Thanks for listening, and I'll try and answer any questions you might have. Want questions now or later?
What kind of training do you provide for judicial workers?
I set up the Judicial College of Victoria when I was Attorney General, and the headlines in the Murdoch press were judges to go back to school, and that was a big tick by my cabinet colleagues. They like to be tough where they can, but initially a lot of the courses conducted weren't attended by judicial officers who believed they knew everything, and why should they go back to school, and why should they learn about cultural sensitivity, and why should they learn about listenability and the things I've spoken about. I appointed a large number of judicial officers, so the ones I referred to before weren't the ones I appointed, and they are indeed embracing ongoing education and training. Many of them get this stuff. They get this stuff, and the college does offer a whole range of courses that deal with many of the issues I've spoken about. That's it.